I call the court to order. As has already been explained, the court has been convened to consider the charge against Cash. And this charge, against which the jury and yourselves will be invited to adjudicate, has three components. As already been explained, I shall be brief. It is an inefficient means of payment. It is an important part of many aspects of criminal activities, and that it is a constraint on the conduct of monetary policy if and whenever negative interest rates are required. Those are the three elements of the charge, and I will be inviting the jury towards the end to adjudicate on each one of those three separately. My learned friends, the counsel for the prosecution, will lead the charge, and they are Michela Marcuson, Esther Joqueville, and Donato Maciandaro. Of course, the accused cannot physically appear in the witness box. However, they are very ably represented by my learned friends, the counsel for the defence. And they will be Christoph Hedrick, Deborah Rantella, and Thomas Hertatz. So welcome to all of them. The proceedings will be conducted according to English law and English court proceedings. However, towards the end, I might modify that. I will use the judge's discretion to modify that in terms of what the options are for the jury. It is normally thought, as most of you will probably be thinking at the moment, that under English law and probably most law, there are two possible verdicts, guilty or not guilty. I might introduce a change to that and introduce an element of Scottish law and Scottish legal proceedings, which adds a third option, namely not proven, which means that there might be a prima facie case for a guilty verdict, and yet the important test of beyond reasonable doubt is not met. In that case, it opens the possibility of a retrial at a later stage. But that is not for me to decide. So the procedure will be the case of the prosecution. The defence counsel will call three witnesses for each of the three parts of the charge separately. They may be cross-examined, those witnesses may be cross-examined by the counsel for the defence. Then the counsel for the defence will call three witnesses separately for each of the charges, and in turn they may be cross-examined by counsel for the prosecution. We also have two court expert witnesses, and they will be Doris Schneeberger and Cecilia Skingsley. I do apologise to both for my pronunciation. They will give their independent opinion for the court. Final statements and pleadings will then be made separately by the counsel for the prosecution and counsel for the defence. Unusually, in most cases in the UK, in fact all cases, the public do not take part in the proceedings. And in fact, if they do, the judge has the discretion to fine them or even impose a prison sentence. We will not do that, except in very serious cases. So, in other words, we will adopt Zimbabwe procedure, which means that you will be given the opportunity as members of the public, not part of the court, to express your opinion. We will also have two other independent outside views. Towards the end, I will instruct the jury, and they will consider the three elements of the charge separately. I will ask if it is possible to have a unanimous verdict. If that is not possible, the judge might accept a majority verdict, provided there is a substantial majority one way or the other. And I, the judge, will give the final ruling. I must emphasize that everyone in the public gallery and my learned friends, prosecution and defence, must respect the integrity and the rules of the court, especially over timing. As has already been explained, we have a very tight schedule. And all participants have been advised about that schedule. Any infringement of the rules will be regarded as contempt of court. And in English procedure, contempt of court is a very serious charge. And again, that can, at the discretion of the judge, carry a sentence of a fine or even imprisonment. I certainly hope that that will not be possible on this occasion. There'll be 2 or 3 occasions when, regrettably, I will have to adjourn the court for 15 minutes because I have another serious court case to attend to where I'm the adjudicating judge. It is called Brexit.